Hello, everyone. Amazon activists firing deemed illegal by labor board officials. Fledgling union seeks election at Staten Island warehouse. Company has been grappling with unprecedented wave of activism. Well, when you foster this kind of thing, this is what you get. U.S. Labor Board prosecutors plan to formally accuse Amazon.com Inc. of illegally firing an activist who was trying to unionize its New York warehouses. Unless the company first settles the case, the fledgling Amazon labor union alleged in November that Amazon illegally fired one of its organizers, Daquan Smith. The National Labor Relations Board's Brooklyn-based regional director found merit in those allegations and, quote, will issue a complaint if the case does not settle, end quote. Agency spokesperson Kayla Blado said Friday the complaint would allege an illegal retaliatory firing as well as other violations of the law, she said in an email. Amazon is, of course, going to settle this, in my opinion. They're getting enough bad press just from how it's gotten this far. Amazon didn't immediately respond to a request for comment. The ALU, founded by current and former Amazon employees, has filed a petition to hold an election at 4 of the e-commerce giant's facilities in Staten Island. A hearing on the request is scheduled for next month. Derek Palmer, the group's vice president, said getting Smith reinstated could help galvanize support for the ALU, Amazon labor union. It would be monumental for him to go back to the same building that he was terminated from and speak his truth, and let workers know that it's okay to speak out, which it should be. If you're speaking out about something that's true, you don't need to call it your truth, though. You could just say, you're speaking out truth, okay? Amazon has been grappling with an unprecedented wave of activism and organization in North America, including walkouts over safety concerns in Staten Island and elsewhere, as well as unionization drives in Alabama, Canada, and New York. As far as safety concerns, we went over this. I'll link the video. We went over about how Amazon could potentially be liable for the deaths a few months ago from the tornado. Workers in Bessemer, Alabama, voted not to join the retail workout, wholesale, and department store union last year, but the labor board ordered a do-over after the union accused Amazon of misconduct, which the company denied, of course. The fresh mail-in election is scheduled to commence next month. In December, Amazon reached a settlement with the labor board requiring the company to inform workers nationwide of their legal rights and let employees organize on its property during their time off. U.S. labor law prohibits companies from retaliating against workers for taking collective action to improve their working conditions, including union organizing. But the labor board, which is tasked with prosecuting alleged violations of the law, has no authority to make companies pay punitive damages, and disputes over alleged retaliatory firings can drag on for years, derailing organizing efforts even if the employee eventually prevails. I think that's what usually happens. The person heading up the organization gets fired. I think this happened at the Young Turks as well. They get fired, which kind of chills the attitude in the room, so to speak, and any legal action taken it takes so long to get rolling and get any results that the people who work there kind of are disheartened and lose interest in the cause. I think that's what usually happens. NLRB regional offices investigate claims, and if they find merit in them and can't reach a settlement, issue complaints, which are then considered by agency judges. The judges' rulings can be appealed to NLRB members in Washington, D.C., and from there into federal court. The NLRB's top prosecutor, General Counsel Jennifer Abruzzo, has said she plans to, quote, aggressively seek federal court injunctions to get wrongly fired employees back to work more quickly. She is also pursuing additional remedies along with reinstatement and back pay, such as making companies compensate workers for health insurance costs they incurred because of their termination. I'm not sure what health insurance costs you would incur because you were fired. But that's the other thing. If the person heading up the organization is fired, they're not there to keep people organized and keep people energized about about the union. Their voice is gone. The ALU is urging the agency to take such steps in the case of Smith, who has recently been homeless. The only way he is going to get any justice is through an injunctive order, the union's attorney Seth Goldstein said Friday. So the guy got fired and now he's homeless. And of course, Bloomberg wants me to purchase a subscription. We're going to go to our second story today. Google, this is also a legal story from a tech company, so this is why I've kind of bundled them together. Google denies Facebook collusion claims in new court filing and blog post. A lawsuit by state attorneys general fails to provide evidence of anti-competitive behavior, the company says. So this came out not too long ago about this collusion, and we'll read and they'll give us details about what they're alleging. But Google has come out with a statement denying any such collusion. But let's read on. Google has filed a motion to dismiss the antitrust complaint filed last week, which alleges it colluded with Facebook to manipulate programmatic ad markets. Quote, state plaintiffs complaint, cheered on by a handful of Google's rivals who have failed to invest properly, compete successfully, or innovate consistently. So we're going to read this again without the editorializing here. State plaintiffs' complaint might serve the narrow interests of those rivals, Google argues in the motion, but it also threatens to stifle the dynamism that drives Google and other firms to deliver the products on which businesses and consumers depend every day. So this is a quote from Google itself. This is not the website here editorializing. This is Google saying, our competitors simply haven't invested as much as we have, and they haven't been as successful, and they haven't innovated, so that's why they're mad. But also threatens to stifle any dynamism that drives Google and other firms to deliver the products on which businesses and consumers depend every day. So people depend on our, to me this sounds like people depend on our monopoly. So, originally filed in November, the antitrust suit has been led by Texas Attorney General Ken Paxton of Texas, naturally, and has gradually revealed more allegations through a series of revised complaints. The complaint filed last week provided particularly specific details about Google's alleged collusion with Facebook, including a project named Jedi Blue that the suit says intended to limit ad header bidding practices. The new complaint relies on internal emails that show the Jedi Blue deal was reviewed with input from Google CEO Sundar Pichai and Meta Facebook CEO Mark Zuckerberg and CEO Sheryl Sandberg. But Google has denied that the deal involved any anti-competitive behavior and says it was approved without Pichai's direct approval. Adam Cohen, director of economic policy at Google, wrote in a blog post accompanying the new response that the allegations are, quote, more heat than light, and that Google doesn't think they met the legal standard to bring the case to trial. The complaint misrepresents our business products and motives, and we are moving to dismiss it based on its failure to offer plausible antitrust claims, he wrote in the post. At the heart of the there's a fly buzzing around me somewhere. At the heart of the lawsuit is the allegation that publishers are so this is going to explain exactly what the complaint is. At the heart of the lawsuit is the allegation that publishers are forced to use Google's ad server to access its ad exchange. But Google says this claim is incorrect, and AG Paxton offers no evidence to prove otherwise. End quote. The company also disputes allegations that it has held back rivals from using its open bidding program and that it rigged ad auctions to favor Facebook. In addition, Cohen says the lawsuit is based on outdated information, quote, that bears no correlation to our current products or business. Is he admitting they used to collude? I'm not sure. That's kind of what it seems like. The new complaint quoted a 2015 email in which, quote, Google employees expressed fear that Google's exchange might actually have to compete with other exchanges at some point in the future. A newly unredacted section of the complaint also alleges that Google made concessions to Facebook as part of Jedi Blue, which gave Facebook an advantage in auctions. In its motion to dismiss, Google argues that the lawsuit does not illustrate any anti-competitive conduct. Quote, despite amassing a lengthy collection of grievances, each one comes down to a plea for Google to share its data or to design its products in a way that would help its rivals, end quote, the motion states. Quote, the Sherman Act requires no such thing. None of the conduct alleged in the complaint falls into the narrow exception to the general rule that any firm may choose with whom it will deal, and courts rightly skeptical of challenges to how a company designs its own products, especially when innovation creates more choices for consumers. Yes, but are they innovating or are they colluding? Are they cutting out certain actors? Google also disputes Paxton's claim that the company secretly colluded with Facebook Audience Network via its open bidding agreement, with Cohen noting that the agreement is not exclusive and that it, quote, announced Facebook Audience Network's participation as one of over 25 partners in our open bidding program, all of whom signed their own agreements to participate. Cohen added that Facebook participating in the agreement benefits advertisers and publishers. Quote, in fact, if Facebook Audience Networks weren't a part of open bidding, A.G. Paxton may have claimed that we were preventing a rival from accessing our products and depriving publishers of additional revenue, he wrote in the post. So there's your update on that. This is going to drag out for a long time, but now you have an update. Google, of course, is saying, hey, we didn't do anything wrong. They've kind of brought their defense, at least to the public. So there's that. We'll have more for you in the next video. Kind of your legal tech update for the week. Thanks for watching. Subscribe if you haven't yet, and we'll see you in the next video. Thanks.